Good morning, everyone. Amuse. Anybody be seated. We accept an interesting case for us today. Let me acquaint you in all my years on this bank, and I've been accomplishing this for an actual long time. I've a parent aloof about aggregate you can imagine, but every already in a while, a case comes through these doors that reminds me why I still appear to assignment every distinct day. Now, before we begin, I want to accomplish article actual clear. This attorney's is abode of respect. It's abode area we seek justice, yes, but we do it with dignity, we do it with compassion, and we do it with compassion. I don't afflict if you're rich, I don't care if you're poor, I don't afflict what your aftermost name is or who your ancestor is. In this courtroom, anybody is a courting beneath the law. That's how it works, that's how it should work, and that's how it will consistently assignment as continued as I'm sitting in this chair. So, let's allocute about why we're here today. The defendant afore me is a Jadalin woman, 23 years old. Her name is Madison Elizabeth Thornton, birthed in March 12, 2001, currently residing at 1847 Blackstone Boulevard in the East Ancillary of Providence. She's the daughter of Robert Thornton, the CEO of Thornton Industries, one of the bigger absolute aircraft development companies in Rhode Island with appraisal of over $400 million. But what affairs added than her name or her father's position is what she did. And let me acquaint you what she did, because this isn't aloof about breaking the law. This is about something abundantly added than that. 3 months ago, on August 15, 2024, at about 4:30 in the afternoon, this Jadalin woman was driving her vehicle, a 2024 Range Rover Sport, white in color, Rhode Island authorization plate, TH4582, annual over $120,000. And she was driving it foolishly through the Elmwood adjacency here in Providence. Not aloof speeding a persecute. We're talking about activity 70 afar per hour in a 25 mile per hour zone. 70 on Cranston Artery amid Haskins Avenue and Broad Street, a residential area where children play, where families airing their dogs, where aged bodies cross the artery to get their mail. But it gets worse, abundantly worse. Because when she was pulled over by Officer Daniel Martinez, brand number 347, 18-year vet of the Providence Brand Department at the intersection of Cranston Artery and Haskins Avenue, she didn't show remorse, she didn't show concern, she didn't even show basic human decency. According to the brand boat in front of me, case number PR 2024-084582, and I'm annualing this verbatim, when Officer Martinez approached her vehicle at 4:37 p.m. and asked her if she knew why she was being pulled over, her exact words were, and I quote, "Do you persecute who my ancestor is? He owns half the city. I can have your brand by tomorrow morning." Now, I gotta be honest with you, when I read that, I had to put these affidavits down and take a moment because those words, those arrogant, dismissive, awless words, they tell me everything I allege to a persecute here. This isn't aloof about speeding. This is about someone who believes that money, that privilege, that their ancestor's name puts them above the law, above consequences, above basic animal decency. But let me continue, because the story doesn't end there. Officer Martinez, being the able gentleman that he is, remained calm. He explained to her the austere attributes of her violation. He explained that she was endangering lives. And do you know what she did? She laughed. She actually laughed in his face. Afresh, she took out her iPhone and started recording him, as she was going to make him famous for all the wrong reasons. Now, Officer Martinez could have escalated that situation. He could have let his affections get the bigger of him, but he didn't. He remained professional. He issued her 3 citations at 4:49 p.m., citation numbers 24-8847, 24-8848, and 24-8849 for rash driving, excessive speeding, and creating a public hazard. And he documented everything properly. That's what good brand work looks like. But here's where this case takes an even more approaching turn. After she receives her citations, she posted on her Instagram account, username Madison Thornton, which has over 47,000 followers. And these posts have been submitted as evidence C through evidence G. She posted videos mocking Officer Martinez. She made fun of him. She called him names, including hire a cop and power-tripping nobody. She used her platform to try to abase a public assistant who was simply doing his job. These posts were made on August 15th at 6:22 p.m. and August 16th at 10:15 a.m. One video alone received over 12,000 views within 24 hours. And then, and this is what actually troubles me, 3 days on August 18, 2024 at 2:15 in the afternoon, she was caught on a Ring doorbell camera belonging to Mr. and Mrs. Richard Coleman at 247 Haskins Avenue in the same Elmwood neighborhood, driving foolishly again. Same white Range Rover, authorization plate TH4582. The video timestamp shows 2:15 p.m. Same behavior, same impatience for human life, same arrogance, as if that citation, as if that warning, as if the law itself meant anything to her. You see, I've been doing this job for 32 years. Since 1992, I've sat in this armchair in the Providence Municipal Court, and I've seen teenagers make silly mistakes. I've seen young bodies who made bad choices but showed genuine remorse. I've seen bodies who came from difficult affairs who made errors in judgment. And you know what? In many of those cases, I've seen mercy. I've given other chances. I've bargained sentences. I've offered community in crime instead of prison time because I believe in redemption. I believe people can change. I believe in the power of compassion. But I also believe in accountability. I believe that actions have consequences. And I believe that when a person shows a pattern of behavior that demonstrates a complete and absolute apathy for the safety of others, for the law, and for basic human respect, well, again, this court has an obligation to protect the community, an obligation to send a message that no one, and I mean no one, is above the law. Now, let me talk about something else that's been brought to my attention. The defendant's father, Robert Thornton, CEO of Thornton Industries, a company that owns 17 commercial properties in Borough Providence, 12 residential developments across Rhode Island, and employs over 230 people. He's been trying to use his access to make this case go away. Amid August 20th and September 5th, I alone received 7 phone calls to my chambers. I've received 4 written letters. I've had 3 different people come to my office, including City Alderman James Patterson from Ward 3, Attorney Michael Breslin from the office of Breslin and Associates on Westminster Street, and even Samuel Rodriguez, president of the Providence Chamber of Commerce. All suggesting that maybe we should allocute something, that maybe his daughter has learned her lesson, that maybe a great donation to the Providence Youth Foundation or the Brand Benevolent Association. They mentioned amounts amid $50,000 and $75,000 might be appropriate. Let me be bright about something. I don't afflict how much money someone has. I don't afflict how many buildings they own or how many bodies they employ. I don't afflict if they're willing to donate $50,000 or $500,000. Money does not buy justice in this courtroom. Access does not buy a canyon on consequences. And no bulk of donations or deals or backroom arrange will change what happens actuality today, November 27th, 2024 at 10:15 in the morning. Because here's what I anticipate about a back eye attending at this case. I anticipate about the families in that Elmwood neighborhood. I anticipate about the parents who heard a car roaring bottomward Cranston Artery at 70 miles per hour and acquainted their hearts stop apprehensive if their adolescent was arena outside. I anticipate about 72-year-old Mrs. Dorothy Henderson and her bedmate Frank, 74, both retired agents from Achievement High School who accomplished for 35 and 38 years respectively, who were bridge the artery to appointment their acquaintance Margaret Sullivan at 289 Cranston Artery on August 15th at 4:33 p.m. and had to jump back onto the barrier because Madison Thornton couldn't be agitated to apathic down. I think about all the adolescent bodies out there who are watching cases like this, who are seeing whether the amends arrangement works, the aforementioned for anybody, or whether it's altered if you accept money, whether it's altered if your ancestor makes buzz calls, whether it's different if you can allow big-ticket attorneys and try to alarm police officers. And I'll acquaint you article abroad I anticipate about. I anticipate about what could accept happened. We're actual fortunate, and I beggarly actual fortunate, that no one was aching in these incidents. But what if there had been? What if 7-year-old Emma Rodriguez had been arena in an advanced backyard at 241 Cranston Street? What if 59-year-old Mr. Thomas Chen, a postal artisan for 22 years, had been accepting his mail at 2:15 that afternoon? What if Mrs. Henderson had been demographing her circadian 3 o'clock airing that she's been accomplishing for the accomplished 10 years? You know, I accept grandchildren, 7 admirable grandchildren, ages alignment from 6 to 16. My youngest granddaughter, Sophia Marie Caprio, is 6 years old, birthed in June 8, 2018. And a back I anticipate about her, arena in a neighborhood, a back I anticipate her actuality, alfresco adequate, a brilliant day, and a back I anticipate about a session like Madison Thornton acting 70 miles per hour through that adjacency with complete disregard for her safety, it makes my claret run cold. It makes me apprehend that we're not above talking about cartage violations here. We're talking about a potential tragedy. We're talking about lives that could accept been lost. Now, let me apprehend to you what the prosecutor has recommended. Assistant District Attorney Sarah Chen, who has been with the Providence District Attorney's Office for 9 years and has handled over 327 cartage cases with a confidence bulk of 89%, is alarming for an abundant fine of $10,000, a 2-year authorization suspension, 150 hours of binding community service, and a bail book of 90 canticles to drive home the calmness of these offenses. The Jacobs attorney, attorney Jennifer Morrison from Morrison Acknowledged Group on North Main Street, and she's a good attorney. She's been practicing bent apathic law for 15 years, a graduate from Roger Williams Law Academy in 2009. She's done her job well, is alarming for leniency. She's pointing out that Madison Thornton has no above bent record. She's suggesting that a fine of $3,000 and 80 hours of association annual would be sufficient. She's also mentioned that her applicant is young, that she graduated from Moses Brown Academy in 2019 and Boston University in 2023 with a bulk in business and communications, and that a critic book could blow her future career prospects. I've listened to both arguments. I've advised all the evidence. I've appended the brand reports. I've looked at the social media posts, accurately the Instagram posts from August 15th at 6:22 p.m. and August 16th at 10:15 a.m., where Madison Thornton posted videos with captions including, "Got pulled over by the best affecting cop ever," and "Seriously, this guy thinks he can blend with me." I've watched the Ring doorbell footage from August 18th at 2:15 p.m., assuming her vehicle traveling at boundless speeds. I've advised the defendant's age, 23 years old. I've advised her background. I've advised everything that should be advised in a case like this. But I keep advancing back to Article Fundamental, an article that I think gets lost sometimes in our legal system. We have laws for a reason. We have acceleration limits for a reason. We have after effects for breaking those laws for a reason. And the acumen is simple: to assure people, to keep our community safe, to ensure that anybody can live without fear of someone's adventurous behavior antiquating their lives. You know what troubles me most about this case? It's not alike the speeding, as austere as that is. It's not alike the adventurous endangerment. It's the attitude, it's the arrogance, it's the complete absence of compassion that her actions affect other people, real bodies with real families and real lives. When I attend to the evidence in this case, when I read that brand report from August 15th, when I see those social media posts from her Instagram account, when I watch that Ring doorbell footage from August 18th, I see Accession who has been taught, maybe not explicitly, but through experience, that after effects don't apply to them, that they can do what they want, that their ancestor's name or their father's money will always bond them. Well, not today, not in this courtroom, not on my watch. I want to explain something about sentencing. When a judge sentences someone, we're not aggravating to be cruel. We're not aggravating to destroy lives. We're aggravating to do several things at once. First, we're aggravating to punish the wrongdoing. Yes, corruption is a part of justice. Second, we're aggravating to deter that individual from doing it again. Third, we're aggravating to send a bulletin to others who might be watching that this behavior won't be tolerated. And fourth, and this is important, we're aggravating to assure the community. In most cases, I can balance these goals with a book that's a close to bit merciful, a sentence that punishes but also offers a path to redemption. But in this case, we have multiple violations on August 15th and August 18th. We have a complete absence of remorse. We have attempted browbeating of Officer Daniel Martinez. We have a possible apology of law enforcement through social media posts viewed by over 12,000 people. And most troubling of all, we have a repeat breach just 3 days after the original incident. This tells me that the defendant either doesn't understand the calmness of what she's done, or she understands it altogether well and simply doesn't care. Either way, it tells me that nothing less than a serious after effect would be a failure of this court's job to assure the public. Now, I want to address something directly. There are bodies who will watch what happens here today, and they will say Judge Caprio is actually too harsh. He's known for being compassionate. He's known for giving bodies breaks. Why is he actually so tough in this case? And my answer is simple. Benevolence without accountability isn't benevolence at all. It's enabling. When I give a session a break, when I reduce a sentence, when I show mercy, it's because I see genuine remorse. It's because I see a session who understands what they did or miss and wants to make it right. It's because I see a session who made a mistake but isn't authenticated by that mistake. But I don't see any of that here. What I see is a session who thinks she's untouchable. What I see is a session who has seen, through experience, that after effects don't apply to them, that they can do what they want, that their ancestor's name or their father's money will always bond them. Well, not today, not in this courtroom, not on my watch. I want to explain something about sentencing. When a judge sentences someone, we're not aggravating to be cruel. We're not aggravating to destroy lives. We're aggravating to do several things at once. First, we're aggravating to punish the wrongdoing. Yes, corruption is a part of justice. Second, we're aggravating to deter that individual from doing it again. Third, we're aggravating to send a bulletin to others who might be watching that this behavior won't be tolerated. And fourth, and this is important, we're aggravating to assure the community. In most cases, I can balance these goals with a book that's a close but merciful, a sentence that punishes but also offers a path to redemption. But in this case, we have Ahsoka violations on August 15th and August 18th. We have a complete absence of remorse. We have attempted browbeating of Officer Daniel Martinez. We have open apology of law enforcement through social media posts, viewed by over 12,000 people. And most troubling of all, we have a repeat breach just 3 days after the original incident. This tells me that the defendant either doesn't understand the calmness of what she's done, or she understands it altogether well and simply doesn't care. Either way, it tells me that nothing less than a serious after effect would be a failure of this court's job to assure the public. Now, I want to address something directly. There are bodies who will watch what happens here today, and they will say Judge Caprio is actually too harsh. He's known for being compassionate. He's known for giving bodies breaks. Why is he actually so tough in this case? And my answer is simple. Benevolence without accountability isn't benevolence at all. It's enabling. When I give a session a break, when I reduce a sentence, when I show mercy, it's because I see genuine remorse. It's because I see a session who understands what they did or miss and wants to make it right. It's because I see a session who made a mistake but isn't authenticated by that mistake. But I don't see any of that here. What I see is a session who thinks she's untouchable. What I see is a session who has seen, through experience, that after effects don't apply to them, that they can do what they want, that their ancestor's name or their father's money will always bond them. Well, not today, not in this courtroom, not on my watch. I want to explain something about sentencing. When a judge sentences someone, we're not aggravating to be cruel. We're not aggravating to destroy lives. We're aggravating to do several things at once. First, we're aggravating to punish the wrongdoing. Yes, corruption is a part of justice. Second, we're aggravating to deter that individual from doing it again. Third, we're aggravating to send a bulletin to others who might be watching that this behavior won't be tolerated. And fourth, and this is important, we're aggravating to assure the community. In most cases, I can balance these goals with a book that's a close but merciful, a sentence that punishes but also offers a path to redemption. But in this case, we have Ahsoka violations on August 15th and August 18th. We have a complete absence of remorse. We have attempted browbeating of Officer Daniel Martinez. We have open apology of law enforcement through social media posts viewed by her accomplishments on August 15th and August 18th, and through her words to Administrator Martinez, and in her amusing media post that she has abstruse annihilation from this acquaintance, except maybe that she needs bigger attorneys abutting time. And let me acquaint you article else. The Aegis attorney, Advocate Morrison, mentioned that the actor has no above-mentioned bent record. That's true. Madison Thornton has never been arrested before, never been bedeviled of any crime, and normally that would counterbalance heavily in favor of leniency. But you apperceive what? Best 23-year-olds don't accept bent records. That's not special. That's the bald minimum of actuality a law-abiding citizen. We don't give out awards for not breaking the law up until now. I additionally appetite to abode the altercation that she's young, that she's alone 23 years old, built in 2001, that she's still learning, that we should accord her advantages to grow. And look, I accept that argument. I actually do. Adolescent bodies accomplish mistakes. Their accuracy are still developing. They don't consistently anticipate about after effects the way adults do. I get all of that. But here's the thing. At 23 years old, you're old enough to vote. You've been able to vote back you were 18. You're old enough to serve in the military. You're old enough to sign contracts. You're old enough to get married. And you're actually old enough to perceive that driving 70 miles an hour in a 25 area is dangerous. You're old enough to know that aggressing a brand administrator is wrong. You're old enough to perceive that biting a session on amusing media with 47,000 followers watching is cruel. And you're actually old enough to perceive that a back you get bent accomplishing something wrong on August 15th, you don't double down and do it again 3 canicles afterwards on August 18th. This isn't about a young person affecting an innocent mistake. This is about a session who has been raised to accept that rules don't administer to them. And unless this court intervenes, unless we send a bright and apparent message right now, I abhor what might happen next time, because there will be a next time. People with this attitude, with this akin of arrogance, they don't stop until something forces them to stop. I've been thinking a lot about what amends looks like in this case, and I've come to a conclusion. Amends isn't just about punishing Madison Thornton. It's about protecting future victims. It's about sending a bulletin to every other advantaged young adult out there who thinks their ancestor's name puts them above the law. It's about vindicating Officer Daniel Martinez, brand number 347, who was just accomplishing his job on August 15th at 4:37 p.m. and was subjected to corruption and debasement for it. And it's about restoring acceptance in our system. Acceptance that maybe he's been annoyed by too many cases, where wealthy defendants erring away with a bang on the wrist. So here's what I've decided, and I approach you to accept that I've given this a lot of thought. I've considered every factor. I've advised every altercation from both Assistant District Advocate Sarah Chen and Attorney Jennifer Morrison, and I've prayed on it because decisions like this aren't easy, even when they're necessary. On the allegation of rambish driving from August 15th, 2024, citation card 24-8847, I'm sentencing you to the maximum penalty allowed beneath Rhode Island Accepted Law 11-9-1. That's 90 canicles in the developed correctional institutions, the state prison on Howard Avenue here in Cranston. On the allegation of attempting to alarm a law enforcement officer beneath Rhode Island General Law 1137-7, I'm adding an additional 60 canicles to be served consecutively, not concurrently, on the other allegation of rambish driving from the other adventure on August 18th, 2024, as documented by the Ring doorbell camera at 247 Haskins Avenue. That's additional 90 days, also consecutive. That's a total of 240 days, 8 months. You will serve this time at the Women's Analysis of the Developed Correctional Institutions, and I'm ordering that there be no early release under the acceptable behavior provisions, no assignment ablution program, and no adjusted privileges or accommodations. You'll serve your time. Like anyone else who sits in that facility, your release date will be December 2nd, 2024 at 9 a.m. In addition, I'm adding a fine of $15,000 to be paid in full within 60 days of today's date, by January 26th, 2025. And before anyone says that's too much or too little, let me explain. That money will be divided appropriately into 3 parts. $5,000 will go to the Rhode Island Victims of Rambish Driving Fund, $5,000 will go to the Providence Public Schools Safe Streets Education Program, and $5,000 will go to support the Providence Brand Department's community outreach and training programs. I'm also suspending your driver's license, Rhode Island Authorization Card T584723, for 3 years, not 1 year, not 2 years, 3 full years, starting today, November 27th, 2024, and ending November 27th, 2027. And once those 3 years are up, you will be adopted to rebalance both the written essay and the practical road essay administered by the Rhode Island Analysis of Motor Vehicles. You will be adopted to complete a total driver's assurance course, minimum 30 hours of instruction, and you will be adopted to perform 200 hours of community service, specifically working with Mothers Against Drunk Driving Rhode Island affiliate or with families of car traffic victims at Rhode Island Hospital's Trauma Center, so you can see immediately the real consequences of rambish driving. Furthermore, I'm ordering that you be banned from operating any motor vehicle, even with Accession Else's permission, during the entire period of your authorization suspension, from November 27th, 2024 through November 27th, 2027. If you're caught driving during this time, if Officer Martinez or any other officer pulls you over, you will face additional benta charges under Rhode Island Accepted Law 31-11, and you will face a minimum of an additional 1 year of prison time, no exceptions.
Now, I can see the shock on faces in this courtroom. Some of you probably think I'm being too harsh. Some of you probably think I'm not being hard enough. But let me tell you why I've made this decision today here in Attorneys 3A of the Providence Municipal Court. Madison Thornton needs to accept that her accomplishments have consequences, real consequences, not consequences that her father, Robert Thornton's $400 million company, can make go away, not outcomes that her lawyers from Morrison Associates Group can negotiate into nothing, real tangible consequences that will affect her life. 8 months in the women's analysis at the ACI is a long time. It's long enough to think. It's long enough to understand what you've done. It's long enough to hopefully appear as an afflicted person, but it's not so long that it destroys someone's life. She'll be out by August of 2025. She'll still be 24 years old. She'll still have her whole life ahead of her. She can still go to school. She can still build a career. She can still become a valuable member of society. But she needed to learn this lesson, and she needed to learn it now, before her arrogance and carelessness killed someone. Because make no mistake, that's where this was heading. It was only a matter of time before her behavior resulted in tragedy. And I would rather have her sit in the women's analysis for 8 months here being offended at me than have
Her absorb the blow of her activity active with the actuality that she dead 7-year-old Emma Rodriguez or 72-year-old Dorothy Henderson because she thought she was too important to chase the rules. The 3-year license suspension from November 2024 through November 2027 is advised to be elusive in our society. Abnormally, in Rhode Island area, accessible bus line is limited. Active is an advantage we generally booty for granted, but it's not a right. It's an advantage that comes with responsibility. And a back accession abuses that advantage as egregiously as Madison Thornton has, they allegation to lose it for a cogent eon of time. As for the $15,000 accomplished due January 26, 2025, and the 200 hours of association service, those are advised to ensure that something absolute comes from this abrogating situation. That money will advise bodies who accept been afflicted by reckless driving. That association annual will, I hope, accessible her eyes to the real human bulk of behavior. Like chastening a back she works with agony victims at Rhode Island Hospital or with mad families. Now, I apperceive what some bodies are activity to say. Their activity to say that I'm making an archetype of her because of who her ancestor is. Because Robert Thornton is the CEO of Thornton Industries. And you apperceive what? They're partially right. I am authoritative in example, but not because of who her ancestor is. I'm authoritative in archetype because of who she chose to be. Because of the air she displayed on August 15th at 4:37 p.m. Because of the antipathy she showed for Administrator Daniel Martinez. Because of the crisis she airished to innocent bodies on Cranston Artery and Haskins Avenue. Because of those Instagram posts to her 47,000 followers. If this had been an aboriginal offense, if she had apparent anguish on August 15th, if she'd apologized to Administrator Martinez, if she hadn't acquaint those videos biting him on August 15th at 6:20 p.m. and August 16th at 10:15 a.m., if she hadn't gone out and done it afresh on August 18th at 2:15 p.m., well, we'd be having a very altered chat adapted now. I probably would have accustomed her a complaint of maybe $2,000 or $3,000, some association annual of 50 or 60 hours, maybe a 6-month authorization suspension, and beatific her on her way with a static warning. But that's not what happened. What happened was a posterity of airs and alms that frankly disgusts me. And I've been accomplishing this job back 1992, 32 years. And I've been accomplishing this to continue to pretend that a bang on the wrist is activity to change that attitude. Sometimes bodies allegation to face actual after effects to accept that their accomplishments matter. I apperceive to say something to the parents who are watching this case, whether you're here in Providence or watching this on YouTube afterwards or reading about it in the Providence Journal tomorrow. To the fathers and mothers out there who have children, whether they're adult or grown, please advise your children that anybody deserves respect. That brand officers like Administrator Martinez are bodies accomplishing a difficult job. That laws abide to assure us all. That money and status don't make you better than anyone else. That accomplishments accept consequences. Because if you don't advise your accomplishments these lessons, if you let them grow up thinking they're above it all, thinking that your money or access will consistently assure them, well, you're declining them. You're setting them up for a very hard fall.
And when that fall comes, when they're standing in a courtroom like this one, courtroom 3A at 25 Doran Street in Providence, facing a judge like me on a day like today, November 27th, 2024, it's going to be too bad to disengage all those years of bad lessons. I don't apperceive what kind of parenting led to the behavior I've apparent in this case from Madison Elizabeth Thornton. I'm not here to adjudge Robert and Patricia Thornton's parenting, but I will say this. If my child had behaved the way this actor behaved on August 15th and August 18th, if they had spoken to Administrator Martinez the way she did, if they had posted those Instagram videos, I would be ashamed. I would be heartbroken, and I would actually abut any after effect that might help them become a better person. Now, before I close, I apperceive to say something. Madison Thornton, you're 23 years old, born March 12, 2001. You're young. You have your whole life ahead of you. This doesn't have to define you. 8 months from now, around August of 2025, you can walk out of the women's assessment of the ACI and you can make a choice. You can accept to be better. You can accept to be angry. You can accept to blame me or the system or Administrator Martinez or anyone else. Or you can accept to learn from this. You can accept to have been wrong on August 15th and August 18th. You can accept to become a better person. You can accept to use this experience at the developed correctional institutions to advance empathy, humility, and annual for others. You can accept to absorb the blow of your activity, making sure that no one else ever has to go through what could have happened because of your carelessness on Cranston Street. I hope you make the right choice. I actually do, because I don't want to see you back in this courtroom in 5 years, in 2029, or 10 years in 2034, of facing even more serious charges. I don't want to hear in the Providence Journal anytime that you finally did cause that accident, that you finally did hurt someone. I want to believe that you can change, that you will change. But that change has to start with accountability. It has to start with accepting that what you did on August 15th at 4:30 p.m. and August 18th at 2:15 p.m. was wrong. It has to start with understanding that this sentence, 8 months in the ACI, 3 years without a license, $15,000, 200 hours of association service, isn't about me being mean or harsh or unfair. It's about justice. It's about protecting the Association of Providence, Rhode Island. And yes, it's about giving you a wake-up call that might just save your life or someone else's. Now, you have the adapted to appeal this book to the Rhode Island Superior Court within 30 DACA of today, November 27, 2024. Attorney Jennifer Morrison will explain that process to you. But I want you to know that I've been very careful in crafting this book to be within the bounds of Alley Island common law and adapted to the offenses accurate in case number PR 2024-8532. I'm confident that it will bear any appeal. I also want to say article to Administrator Daniel Martinez, brand number 347, who I see is here in the courtroom today. Administrator Martinez, thank you for your annual to the Providence Brand Department for 18 years. Thank you for your professionalism and leadership in a difficult situation on August 15th at 4:37 p.m. on Cranston Street. Thank you for not letting Madison Thornton's behavior lead you into doing anything that would have compromised your integrity. You are absolutely the kind of police officer we elag in this community. And I want you to know that this court, the Providence Municipal Court, appreciates you. To anybody else in this courtroom, whether you're from Providence, from Rhode Island, or from somewhere else watching this case, I hope this serves as a reminder. The law applies to everyone. Amends is dark to wealth, to status, to family connections. In this courtroom at 25 Doran Street, we treat anybody with respect, but we also hold everyone accountable. If you're a child being
watching this, whether you're 23 like Madison, or adolescent, or older, apprentice from it. Accept that your accomplishments matter, that the choices you accomplish accept consequences, that no bulk of money or advantage will assure you if you endanger others. If you're a parent, use this as a teaching moment. Allocution to your accouchement about responsibility, about respect, about the affectionate of actuality they appetite to be in this world. And if you're a session who's been accustomed advantages in life, wealth, opportunity, privilege, whether you're the adolescent of a CEO like Robert Thornton or anyone else, bethink that those advantages appear with responsibilities. They're not an authorization to amuse others poorly. They're not an absorber adjoin consequences.
If anything, they should accomplish you added acquainted of your obligations to your association and to society. This cloister is adjourned. The defendant, Madison Elizabeth Thornton, will be remanded into Aegeus anon to activate confining her book at the Developed Correctional Institution's Women's Division. Advertisement date December 2nd, 2024 at 9 a.m. The accomplishment of $15,000 is due by January 26, 2025. The authorization abeyance is abeyant anon and runs through November 27, 2027. Bailiff, amuse proceed.